Ready? Start. A bare perusal of the law laid down by the Honorable Apex Court in the aforementioned cases would show that the findings of the inquiry officer arrived at in his inquiry report can be interfered with, provided findings are perverse or it is a case of no evidence, however, if there is some evidence to support the conclusion of the inquiry officer, no interference can be made by the High Court under Article 226 of the Constitution of India, inasmuch as adequacy of evidence cannot be subject matter of judicial review. Stop para. A bare perusal of the report of the inquiry officer dated 22/3/2005 demonstrates that the authoritativeness and reliability of the prosecution witness number 1, namely Miss Preeti Shri, has not only been brought under a cloud by the inquiry officer but the said witness has also been disbelieved, and that is why the inquiry officer has exonerated the petitioner and others from the charges of demanding bribe from the allegationist Miss Preeti Shri. Stop. If that be so, then the other charge regarding the petitioner being negligent and careless in not making proper arrangement of police force for effecting delivery of possession and instead submitting a false report for extraneous considerations, is also bound to fall since the inquiry officer has failed to lay his hand on any evidence in support of the said charge, and moreover, he has not congregated any motive attributable to the petitioner herein so as to prove the said charge, apart from him having not found any material to disprove the letter dated 9/12/2003 written by the petitioner to the Superintendent of Police, Bhagalpur, requisitioning police force for deputation on 14/12/2003, as also the letter dated 9/12/2003 written to the subdivisional officer Bhagalpur for deputation of the executive magistrate and armed force on 14/12/2003 at 7 a.m. for the purpose of effecting delivery of possession, in pursuance whereof the subdivisional officer by an order dated 13/12/2003 had not only deputed a executive magistrate but had also requisitioned police force, and copy of the said order dated 13/12/2003 was sent to the Deputy Superintendent of Police Bhagalpur, as also to the officer in charge Kotwali, Bhagalpur, for information and necessary action. Stop. Therefore, there is no material, much less evidence in the inquiry report dated 22/3/2005 to prove the charge levelled against the petitioner regarding him being negligent and careless, having not made proper arrangement of police force for effecting the delivery of possession and submitting false report for extraneous considerations. Stop. In fact, It has also been admitted in the counter affidavit filed on behalf of the respondents number 2 and 3, duly sworn by the Registrar, Civil Court, Bhagalpur, particularly in paragraph number 8, that the petitioner, upon receiving the warrant of affecting delivery of possession, has sent requisition dated 9/12/2003 to the Superintendent of Police, Bhagalpur, for deputation of police force, and another requisition was also sent on the same day to the Sub-Divisional Magistrate, Bhagalpur, Sadar, for deputation of magistrate, fixing the date of execution as 14/12/2003, hence, this court is of the opinion that nothing remains for speculation, and consequently comes to a finding that there is no evidence on record to substantiate the first charge level against the petitioner, to the effect that he had negligently and carelessly not made proper arrangement of police force for effecting the delivery of possession, and with the intention to defeat the writ, he had submitted false report for extraneous considerations. Thus, the findings of the inquiry officer qua the charge number 1 stop over.